Okay. Hello, Mr. Turner, I think you're up.
Good morning. Yes, Your Honor. May it please the court, my name is Christopher Turner. I represent the appellants in this case, Rebecca Bailey and Jonathan Bailey. I'd like to reserve 5 minutes for rebuttal.
Sure.
This is an appeal of a trial court order compelling arbitration of the plaintiff's claims against the appellees. This is a non-final order. And just a brief factual summary real quick. Jonathan Bailey was employed by the appellees as a construction manager. And this is all in the amended complaint, which is in the appendix. He was overseeing the remodeling of a house that was owned by the appellees. And on April 26th of 2017, he entered into the house and suffered serious and permanent injuries as a result of an exposure to harmful gas and asphyxiation. Thereafter, there was a claim made directly with the appellees for workers' compensation benefits. The appellees denied those workers' compensation benefits and filed a notice of denial with the Florida Department of Financial Services on May 2nd of 2017. That notice of denial is in the appendix at page 87. The reason for the denial that the appellees put on there was that the claimant, Jonathan Bailey, did not sustain an accidental compensable injury arising out of work performed in the course and scope of employment. And again, the reason why this is before the court is that the appellees filed a motion with the trial court to compel arbitration because Mr. Bailey signed an ADR arbitration agreement with the appellees. The appellees argue that the arbitration agreement that Mr. Bailey signed requires arbitration of these personal injury claims because they relate to his employment, which is obviously a different position than they took when they filed the notice of denial with the work comp system. There's no dispute that he signed the arbitration agreement. We're not disputing that. On September 10th of 2019, the trial court held a hearing on appellee's motion and granted the motion to dismiss, compelling us to arbitration, and this appeal followed. Both parties agree that this is a de novo standard of review for this case. And I'm sure, as the court knows, under the Florida Supreme Court of Seifert, there are 3 elements essentially that courts look at in determining whether a claim is subject to arbitration. We don't think any of those have been met in this case. And those 3 are whether a valid written agreement to arbitrate exists. Number 2, whether an arbitral issue exists. I can never say that word. And whether the right to arbitration was waived. Starting with the first one, we don't believe this is a valid written arbitration agreement because of the way it's being used in this case to essentially circumvent Mr. Bailey's work comp remedies that he should have been entitled to. Again, they denied his work comp claim, and he relied on that denial and bore the brunt of his medical expenses and his treatment and care for many years, and then hired my office. And in February of 2019, we filed this complaint. Now, I know that there's been questions asked by or raised by appellees at the trial court level and in the brief. Well, why didn't Mr. Bailey file a petition for benefits with the work comp office after it was denied? And the answer to that is that they had already taken the position that it wasn't arising out of the course and scope of his employment. So under the Bailey Citrus Publishing case, which is the 5th DCA case, when the employer makes a denial, denying that it arose out of the course and scope, they're entitled to file suit in circuit court. And Mr. Bailey, we're under the impression that, well, this ADR policy can't apply because they've already said that it doesn't apply, that it only applies to claims arising out of his employment, which they have now changed position on. So
aren't 2 separate standards arising out of his employment and the workers' comp standard?
I'm sorry?
There are 2 separate determinations. You can't hear me?
It's garbled.
You kind of fuzzed out. You probably
for the better. I'll ask it later.
Okay.
I don't think it's COVID-19.
Okay. So our argument under the first element of the arbitration is that because the enforcement of this arbitration agreement under the facts of these case substantially diminishes and circumvents his statutory remedies in violation of Florida's public policy and it's unenforceable. And we cited to the Spiesbach case, which is from this district. And under the arbitration agreement, he is not entitled to an appeal, which he would be under the work comp system. He's not entitled to full discovery. I think the depositions are limited to 4 per side. So that is a restriction of his rights that he would have had under the workers' comp system. On the next element, whether there's an arbitrable issue, we don't believe that there is, because if you look at the actual language of the agreement, the parties never intended to arbitrate work comp claims, which are injuries that arise out of the course and scope of your employment. And if you look at the Seifert case, in that case, they held that no party can be forced to arbitrate a claim that they did not intend to arbitrate. And if you look at the actual arbitration agreement, and we pulled out the sections on page 17 of the initial brief, we highlighted it, and it says that this policy, meaning the arbitration policy, does not prohibit associates from filing claims under workers' compensation and unemployment statutes or administrative charges filed under National Relations Act. So if you stop right there, it says that this doesn't apply to workers' compensation claims. But then it goes on, it says semicolon, however, comma, civil complaints and or appeals arising from such charges, which is different than how it defined workers' compensation claims, are still subject to the policy. And then it on the next page of the arbitration of policy, which is in the appendix at 65, it again makes the same language and uses the same language in terms of workers' compensation claims, which are excluded, but then any civil complaints arising out of any charges, which is a different word, are subject to the policy. So I don't think that based on a plain reading of the policy itself, the arbitration policy itself, that there was ever an intent of the parties to
civil claim is arising from the employment relationship.
The civil claim?
The claim that they want to arbitrate.
It is, but that's different than the position. Well, the arbitration agreement itself says that it doesn't prohibit associates from filing claims under workers' compensation. And it defines those as claims. And then later on, it brings back some of those things back into the arbitration agreement, but it only brings back charges. And the only charges they talk about in the arbitration agreement are insurance statutes or administrative charges. So insurance statutes or administrative charges are subject to the arbitration agreement, but workers' compensation
you file a workers' comp claim, and then you want to go to circuit court and file a claim. Because you filed a workers' comp claim, the only thing that is allowed to be arbitrated are now charges, not claims arising from the employment relationship anymore.
Under a reading of the arbitration agreement, because all of those, the workers' compensation claims and administrative charges, it says associates are not prohibited from filing those. And then it brings back, it says civil complaints and or appeals arising from such charges are still subject to the policy. It doesn't say claims and charges or claims and workers' compensation claims and administrative charges. It just says charges. So if this creates an ambiguity to the court, then it has to be construed against the drafter, which was the appellees. So did I answer your question, Your Honor?
Yes.
Okay. So we don't think that element 2 was met. And then if you look at element 3 of whether a matter should be arbitrated or compelled to arbitration, it's whether or not the party moving waived its right to arbitrate. And we have argued that they waived their right to arbitrate and are equitably estopped from taking an inconsistent position in the trial court case from what they filed in the workers' compensation case. And in the Spiesbach case, it discusses that waiver of a right to arbitration results from active participation in a lawsuit or from taking action inconsistent with that right. And they haven't, in the trial court case, they haven't taken active participation in the lawsuit. So we are not arguing that that's an issue, but we're arguing what they did in the workers' compensation claim by filing a notice of denial is inconsistent with the position that they're taking now, which is at the workers' compensation claim, they said there is no compensable injury arising out of the course and scope of the employment. Okay, we relied on that, filed the circuit court case. Now they're saying, oh, well, this, based on your allegations, yeah, based on the allegations.
You said you relied on that to file the thing. So you're saying this did not, but you agree that it arises from the employment.
You're essentially arguing a judicial estoppel.
Judicial estoppel, equitable estoppel, yes, right, under this. And we argued that, you know, they could have, I mean, there is an arbitration provision under the Workers' Compensation Code. If they wanted to arbitrate the case at that point, there is a provision that they could have done so, which requires approval by both parties and approval by the Workers' Compensation judge, but that didn't happen either. So based on, and we went through the elements of equitable estoppel. I think judicial estoppel is similar, which is that they made a representation that we relied on, that it wasn't arising out of the course and scope. We relied on it, filed suit, and now they've changed their position.
Okay, so now
does judicial estoppel require reliance, or does it just require that you, like if you take a position and you prevail based on that position, on that argument, you can't change the argument later? Whether you relied on it, I mean, you know, you were
right under the Bueno case that we cited for equitable estoppel, judicial estoppel. It says it's the same as equitable estoppel with the added element of successfully maintaining a position in one proceeding. So there was no final determination in the work comp case because we relied on it, because we relied on the
assertion, the denial of benefits or the denial of the claim.
Correct. And we relied on their representation that this wasn't arising out of the course and scope of his employment. So if it's not arising out of the course and scope of his employment,
you rely on it, you just lost.
I'm sorry?
You rely on it, you just lost. On what workers' comp action?
We did.
How did you rely on their position in the workers' comp case? What happened is that they asserted it and you lost. How did you rely on it?
Because they said
that a bandwidth problem, Judge Atkinson.
Oh, sorry.
That's all right. You said you would not pass the "I am not a robot" test on any
Turing test.
Yeah, the Turing test.
The appellants relied on what they filed and relied on what Lennar, the appellants was telling them.
Is there an adjudicated dismissal of the comp claim, or did you just drop your comp claim when they filed that motion?
No, the comp claim, they filed a notice of denial, and there was never a petition for benefits filed. You didn't
petition for a proceeding under comp.
Correct. There was never a petition for benefits filed.
Okay, I got
by
it.
Mr. Bailey.
Okay.
So there was never a.
I understand.
So I got it.
My next question is, which was what I tried to ask earlier, which is, isn't there possibly a difference between the standard for workers' comp, not within the course and scope of employment and the injury, and the standard in the arbitration agreement of arising out of or relating to the employment relationship? Are those the exact same thing?
I don't know what the standard is in the workers' comp system, other than what they put in their denial.
No, because you're saying that because they asserted it, they're now stopped from taking a different position.
Right, because in their notice of denial, it says that he didn't suffer a compensable accidental compensable injury arising from the course and scope of his employment, but now they're saying that this was arising from the course and scope.
No, I think Judge Atkinson's point is there's different language in what's in the arbitration agreement versus just this very narrow course and scope description. He's wanting to know, are you saying that they mean the same thing? Because it's arising from or related to.
Assuming that in the circuit court action, if you get there, you're going to argue that, well, it may not have arisen within the course and scope of employment for my workers' comp claim, but he still owes me money because I got hurt on the job.
Right. I think that this should have been a workers' comp claim from the beginning, and it shouldn't have been denied. But but the Baileys relied on that denial and moved forward with their other remedy that they chose, which is the circuit court case, which brought us here. So I think that the appellees are just taking an inconsistent position in the work comp case when they denied it, saying he wasn't injured in the course and scope of his employment, versus what they're saying now, which is, well, this is related to his employment, so it's covered by arbitration.
Prevailing on that position if there was never adjudication in the workers' comp case? Because you're kind of the horns of a dilemma if that's required, because you're saying you didn't lose, they didn't prevail on that position, which they're now taking contrary position.
Right. They didn't.
He's arguing that this is an equitable estoppel. If they had lost on that position, it would become a judicial estoppel. And if they relied on the assertion, then it becomes an equitable.
Okay.
Right. Yes. That's what we're relying on that point, is equitable estoppel, which I think the three elements for that are met.
Right.
Okay. So I'll reserve for rebuttal if there's nothing else.
Yeah, you got about 6 minutes left.
Okay.
Ms. Sim?
May it please the court. My name is Stephanie Sim from Bowman and Brook on behalf of the Applebee's, Lennar Corporation, and Lennar Homes, both of them defendants below. Your Honors, we're here seeking affirmance of the trial court's order staying the underlying case, pending arbitration, or a judicial determination of plaintiff's workers' compensation case. And I think that the way that the trial court has worded its order is significant. The trial court didn't mandate that this case be arbitrated. It certainly could have done just that, but it said arbitration or a judicial determination of plaintiff's workers' compensation case. And why is that? Because at the hearing on defendant's motion to compel arbitration, plaintiff's counsel spent the entire hearing arguing how this is actually a workers' compensation case because his injury occurred in the course and scope of his employment. And on appeal, his briefs are replete with references suggesting that this is a workers' compensation case. And for the last 20 minutes, he's even conceded that this is actually supposed to be a workers' compensation case. The allegations in his amended complaint further support that this should have been a workers' compensation case. In paragraph 11, he says that he was employed by Lennar as a contract manager.
Let me come back though. Having denied the claim, rejected the claim, claiming it arise out of the course and scope. I'm not terribly sympathetic to that argument here, but I think maybe you might be better with the assertion that the standards are not the same that Judge Atkinson tried to say, and then Judge Kelly said that within the course and scope under the workers' comp is not the same thing as arising out of in the arbitration agreement. You know, the argument being that arising out of it's broader.
Correct. But first,
you're supposed to say yes, Your Honor. You hit the nail on the head.
Yeah.
You did hit the nail on the head there, Your Honor. Absolutely.
But only because Judge Atkinson and Judge Kelly told that to me.
Just briefly in response to the first thing that you said, I respectfully disagree that the notice of denial states that the claim didn't arise out of the course and scope of the employment. What it specifically says is the claimant did not sustain an accidental compensable injury arising out of the course and scope of the employment. Right. So to the extent that plaintiff is claiming that the notice of denial here is relevant at all, I would like to address, after I answer your question briefly, the Byerly case, because I think he misapplies that or misconstrues that to the point that he claims it supports his filing of this action in state court. But even hypothetically speaking, if the notice of denial is relevant, it still doesn't get plaintiff to state court for two reasons. Number one, as I just stated, the notice of denial, the reason stated is that he didn't sustain an accidental compensable injury. In other words, he's not challenging the course and scope of the employment. Lennar is challenging the causation of his injuries are not related to the work that he was performing. And the case law is absolutely clear that not all injuries that occur in the course of the employment are compensable. And there's a series of cases that are cited in our brief where that's exactly the situation. Secondly, an employer isn't stopped just because they submit a notice of denial to a workers' compensation claim from arguing workers' exclusivity. And secondly, to the extent that plaintiff wants to argue for whatever reason that denial is ambiguous, or that it doesn't actually say it was denied out of the course and scope, then his only option for litigating at that point is in arbitration. It is not in state court. And with so I'd like to go back to the Byerly case briefly to explain why it is that that's the situation, that we don't end up in state court. In Barley, the employee was injured in an accident that occurred on the premises of the employer, but the employee had already clocked out for the day. The employer denied her claim for benefits, stating that the employee's injury didn't arise out of the course and scope because she had clocked out. And the employee at that point says, okay, Mr. Employer, I'll accept what you're saying. And she went ahead and she filed her claim in state court. And she alleged in her complaint that she was not an employee at the time of the accident and that she was not covered by workers' compensation. So she accepted that denial at face value to file her claim in state court. In its answer, the employer then turned around and asserted as an affirmative defense that the claim was barred by workers' compensation exclusivity because the injury arose out of the course and scope of the employment, which was completely inconsistent with what they had asserted in the denial. The trial court granted the defendant's motion for summary judgment on that denial, and the Fifth District said, no, wait a minute, Mr. Employer. You can't do that. It would be inequitable for you to deny the workers' compensation claim on the ground that the injury did not arise out of the course of the employment, and then raise it as an affirmative defense the fact that you're immune from tort suit on the ground that the injury did arise from the course and scope. And under those circumstances, the Byerly court states that an employee who had been denied for compensation can do one of two things. They can accept and rely on that denial, as the plaintiff in Byerly did here, and pursue their tort claim outside of workers' compensation, or they can challenge that denial in workers' compensation by filing an administrative position. Byerly doesn't support what's happening here. In this case, unlike Byerly, plaintiff is clearly challenging the workers' compensation denial. He thinks it should have been litigated in workers' comp. He doesn't agree that it should have been denied. He continues to exist as covered by workers' comp, and that he was injured under his employment. So under these circumstances, the proper remedy was for him to file an administrative petition in workers' comp challenging that denial. By trying to litigate what he believes is a workers' compensation case in state court, he's essentially trying to circumvent the exclusivity of workers' compensation. And the trial court clearly saw this below, and at the hearing even advised Mr. Turner that what he was trying to do was have his cake and eat it too. So to that end, given plaintiff's unequivocal argument that this is in fact a workers' compensation case, personally, I don't think the court needs to even address whether this belongs in arbitration, because it should only be litigated in workers' comp, and the trial court's order clearly allows for this result and should be affirmed for that basis. But even assuming Byerly could mean that plaintiff is permitted to pursue a workers' compensation case in state court, which again, I disagree that's what it holds, but like I said, it still doesn't get plaintiffs to litigate, which is something that should clearly be subject to arbitration. And why is that? Well, number one, there's a valid and enforceable arbitration policy in place, which Mr. Bailey accepted not once, but twice as a condition of his employment. And if we're going to view this as a civil tort claims, Your Honor, then plaintiff's negligence action would certainly be subject to arbitration under the terms of the ADR policy, because he's the one that's alleging that this claim arose out of his employment. So it's clearly an arbitrable issue, and he's placing it right smack in the middle of the ADR policy and the language that's stated in there. And under no circumstances have the defendants waived their right to arbitrate. So I'd just like to briefly address those 3 points, starting with the first one, and that's plaintiff's challenge that the ADR policy either violates public policy or violates remedial law by forcing him is what he says, to litigate and resolve his work-related injury claims through arbitration rather than through the workers' compensation system. I mean, and frankly, this is no disrespect at all to Mr. Turner, but I don't understand that argument, because in fact, nothing could be further from the truth. Plaintiff wasn't forced to do anything. He wasn't forced to file this in state court, much less to give up his right to pursue this claim in workers' compensation where it belongs. The ADR policy expressly excludes workers' compensation from arbitration. There's no dispute about that. So had he pursued this workers' comp claim in arbitration, as he should have and as he had the right to do, we would have had no basis to compel arbitration in that situation. And as Mr. Turner stated, the arbitration under the Workers' Comp Act can only occur if the employee and the employer both mutually agree to that and get the consent of the JCC in order to arbitrate. So there's nothing invalid about the ADR policy here. To the extent plaintiff is contending that there's no arbitrable issue here because the ADR policy was not intended to encompass personal injury claims, or it only addresses work-related HR claims, I don't think that interpretation is supported by the plain reading of the ADR policy at all, or the documents actually that plaintiff signed in accepting those terms. For instance, the ADR policy, let's start with the acknowledgement of ADR policy, which is found on page 62 of the appendix, and it was signed by Mr. Bailey on the day that he was hired. It states, the ADR policy covers all disputes that may arise relating to your employment with a company. And by the way, I just want to point out the acknowledgement of ADR policy was a one-page disclosure that advised Mr. Bailey of the existence of the arbitration policy. It explained that by signing it, he was acknowledging and certifying that he received the policy, he read it, and he understood it, and he was agreeing to its terms. So this, I just mentioned that because it's not some obscure document that was hidden in some employment manual or some contract and he hadn't seen it. There's no dispute that he saw it, he read it, and he understood it. And the ADR policy says, this policy applies to all disputes arising from or relating to an associate's employment with a company, including but not limited to any common law or statutory claims arising under state or federal law. I mean, clearly a personal injury tort claim would fall under any common law claim within the provision of this policy. And to that extent, the Florida Supreme Court has also noted, Your Honor, I think this relates to what you were saying earlier, that the phrase arising out of or related to is interpreted broadly to encompass virtually all disputes between the contracting parties, including related tort claims. And that's the case of Seifert versus U.S. Home Court. The policy further includes language such as associate acknowledges and agrees that proceeding under this policy is the exclusive remedy for all the parties for disputes arising from or related to the employment. And 14 months after this incident occurred, 13 months after his notice of denial had been received by him, he went ahead and he signed a policy certification acknowledgement, or not signed, he actually just acknowledged that he had read it, that state a further acknowledgement that the terms of the ADR govern all claims and disputes that I may have at any time relating to the employment with a company. So on multiple occasions, plaintiff was advised that the ADR policy was intended to cover the field of all claims and disputes potentially arising out of his employment, including common law claims. And just as significant as what is stated in the policy is what is not stated in the policy, and that's that the party specifically knew how to accept certain types of claims from arbitration, such as the provisions where they exclude workers' compensation cases, unemployment claims, and administrative charges. And if they had intended to exclude personal injury claims from that, they certainly could have done so, and they didn't. So because the language of the ADR policy is broad enough to encompass all claims and disputes arising from or related to the employment, including personal injury claims, and there's nothing excluding personal injury claims filed outside of workers' comp from arbitration, and plaintiff is alleging that his claim arises out of the scope of his employment, then an arbitrable issue clearly exists here. And the last factor for this court's consideration, Your Honor, is whether the right to arbitrate has been waived. And plaintiff has raised two arguments in this regard. First of all, is that defendants failed to compel arbitration in the workers' compensation case. I think I briefly touched upon this, and I think this argument, it fails, first of all, because it presupposes that there was a workers' compensation case filed to begin with. There's no indication, at least from the available record, that that was ever done. It was simply a notice of injury that was submitted. The employer submitted a notice of denial, but there was no claim filed in workers' comp challenging that. So there wasn't a case that we could have moved to compel arbitration in any ways. And secondly, had a case been filed, as I just said, workers' compensation was accepted from being subject to arbitration under the policy, so there would have been no basis to do that either. And to the extent that plaintiff claims that the defendants were stopped from taking inconsistent positions, again, I disagree that the notice of denial states that the injury didn't arise out of the course and scope. So there's nothing inconsistent about the denial to begin with. And secondly, the denial at this point procedurally in the litigation is irrelevant because Whether a claim falls within the arbitration agreement turns on the factual allegations of the complaint. And here, plaintiff is the one who has alleged that this incident arises out of the course of his employment. That alone sufficiently places him within the ambit of the ADR policy. And as the defendants, we were clearly entitled to rely on what he alleged in his complaint to then file a motion to dismiss or to compel arbitration, saying, well, then you're subject to the ADR policy. And I think plaintiff's counsel has agreed that defendant hasn't taken any other actions that are inconsistent with their right to compel arbitration in this case, such as, serving discovery or anything to that effect. So there's definitely no waiver in that situation, Your Honors. Unless the court has any questions for me, our position is that the trial court was correct in granting defendant's motion to stay the case as to the Lennar defendants pending arbitration or a judicial determination of the workers' comp case where everybody seems to believe this belongs. And we ask that the court affirm.
Thank you, Ms. Sim. Mr. Turner, you're up.
Unmute myself there. Thank you, Your Honor. The initial action taken by the appellees, the first thing they ever filed was this denial of work comp benefits. And in that denial, it says that the claimant didn't sustain an accidental compensable injury arising out of work performed in the course and scope of employment. That to me means that he wasn't injured on the job. So if he wasn't injured on the job and it wasn't related to his employment because it didn't arise out of the course and scope of his employment, then it wouldn't fall under the ADR policy. And the Bayerly case, we're not arguing work comp exclusivity. That's a separate issue for another day. What the Bayerly case sets up is a roadmap that says, okay, when an employer files a denial of work comp benefits and says you weren't injured in the course and scope of your employment, there's two paths you can take. You can file a petition for benefits and challenge it, or you can file a circuit court. Our client, or Mr. Bailey, relied on that denial and went and filed his circuit court case, and which he's allowed to do under the Bayerly case. So now this gets us back to the equitable estoppel issue, which is, did they waive their right by taking an inconsistent position, which we believe they did when they initially filed that first notice of denial? And that gets us back to the third element of whether arbitration can be compelled based on the waiver. So we think the elements of equitable estoppel are there because now they're saying this does arise out of the course and scope of your employment or is related to it, which is not what they said in the notice of denial. So,
but the counsel for the appellee mentioned something that I find important, which is that they have a right to arbitrate claims that themselves in the allegations indicate that it arose out of the employment relationship. In other words, your complaint in circuit court is premised on the fact that he got injured on the job. That's arbitrable. And so I'll give you an example. So let's say, there's a workers' comp claim that someone got mesothelioma for installing asbestos. And the employer says, no, actually, there's not a compensable claim because you really had lung cancer from smoking. And then there's a circuit court action filed saying, I got mesothelioma on the job. The fact that the employer in the workers' comp says it wasn't compensable because it wasn't caused by the job doesn't mean that the claim in circuit court is not arising out of the employment relationship, because in the allegations of the complaint is an allegation that it happened because I was on the job.
And I think that gets back to the second element under arbitration. Now I'm getting feedback, which is that if you read the arbitration agreement itself, it exempts workers' compensation claims, which are by definition injuries, personal injuries that arise, on the job. And then it never brings them back into the fold of the arbitration agreement because it says, semicolon, however, charges, civil complaints and appeals arising out of charges are subject to the arbitration agreement. So I think if you closely read the arbitration agreement, it exempts work comp claims, which are by definition claims for personal injuries, and never brings them back in to the arbitration agreement. So I don't think there's an arbitrable issue at all because of the actual language.
Filed on circuit court. But you assert your work comp claim on circuit court. but the language of the ADR says it exempts those claims being brought in workers' comp, not those brought in circuit court. Apparently, maybe it's better that no one can hear me.
I don't. Sorry, I couldn't understand you.
I think you said, Luke, I am your father.
Okay. Sorry, Judge. I just can't understand you. And I don't have anything else to add unless there's any other questions, Your Honors. We appreciate the time and appearing remote for you.
Well, I'm happy you guys are willing to do it this way too. So that's the end of our docket. We will be adjourned. Thank you both very much.
Thank you, Your Honor.
I often say when people from out of town travel safely, but I don't even need to say that.
Have a good afternoon.
You too.
Thank you.